What's up, court nerds? Time to get served. It's your boy Phil, and in today's video, we're featuring this dingbat, Adam Murray of Iron Mountain, Michigan. And let's check out what he's alleged of doing. How Iron Mountain's own Adam Murray caused schools to go into soft lockdown. I'll let you read the rest because I don't want to get a strike. So just take a gander at what our boy Adam Murray did. Did you read it? So now let's join Judge Lacoste's courtroom for his arraignment and see what he has to say for himself. See you later, nerds.
All right, that helps. Thank you.
Yep.
All right, then. This is the people of the state of Michigan versus Adam Fowler Murray 237391FY. Mr. Murray appears from the Dickinson County Jail via video Zoom. Counsel at first appearance is Dan Jaspin, who appears via video Zoom. The prosecution is present this afternoon in the courtroom through Chief Assistant Prosecutor Kristen Cass. We are live streaming this afternoon to YouTube as well. Mr. McLeod is here from WLUC TV6. They have filed a request and notice for film and electronic media coverage of court proceedings. I'm not sure if you're aware of that, Mr. Jaspin.
I was told.
All right, he is present here in the courtroom as well. We're set for an initial appearance on a felony complaint. Mr. Jaspin, did you have a chance to go over the nature of the charges and the maximum penalties with Mr. Murray?
I did, Your Honor. I believe he understood them, but nevertheless, I would ask the court to go over the complaint with him. I also went over his rights. I believe he understood his rights. He did sign the advice of rights form as well as a waiver of extradition. The court might note that on the advice of rights, on the choices regarding an attorney, I checked that he would be hiring his own attorney or requesting an assigned attorney. When I filled it out, I wasn't positive if he qualified for an assigned attorney. But after I met with him, I did some further research and determined that he would qualify because it would be an undue financial hardship otherwise. And given the nature of the charges, I determined that he does qualify and he is requesting an appointed attorney. So I would intend to appoint myself.
All right, very well. Thank you, Mr. Jaspin. All right, then, Mr. Murray, before I read the complaint aloud to you, you tell me on the record here, what is your full legal name, please?
My full legal name is Adam Fowler Murray.
I'm sorry?
My full legal name is Adam Fowler Murray.
All right, thank you. All right, Mr. Murray, I'm going to read you the complaint aloud. Do you have a copy of it in front of you there?
I do.
All right. The victim or complainant being Raul Padilla. It alleges on or about April 11th of 2023 in the city of Iron Mountain, county of Dickinson, state of Michigan. Count 1 then alleges you as the defendant, Adam Fowler Murray, did willfully and deliberately use the internet or a telecommunications device or system or other electronic device or system to disrupt the functions of the public safety, educational, commercial, or governmental operations within the state with the intent to commit assault with a dangerous weapon, also known as felonious assault, and or homicide, open murder, statutory short form. A felony that the defendant knew or had reason to know was dangerous to human life while intending to intimidate, or coerce a civilian population, or influence or affect the conduct of government or a unit of government through intimidation or coercion, contrary to Michigan compiled law 750.543 subparen P. The maximum penalty for that felony is up to 20 years in prison and or up to a $20,000 fine. Plus court costs are always added on. You could be ordered to reimburse the government for expenses incurred from the violation. Do you understand the nature of that charge and the maximum penalties, Mr. Fowler? Mr.
Yes, I
Murray,
do, Your-
excuse me. Thank you.
Yes, I do, Your Honor.
All right, then count 2 alleges using a computer to commit a crime, the crime which has a maximum imprisonment of 20 years or more. It alleges you did use a computer program, a computer system, or computer network to commit, attempt to commit, conspire to commit, or solicit another to commit terrorism, using the internet / telecommunications to commit. Contrary to Michigan compiled law 752.796 and MCL 752.797, paren 3, paren F. This is also a felony, punishable by up to 20 years and or up to a $20,000 fine plus court costs. You could be required to reimburse the government for expenses incurred in relation to violation in the manner indicated by law. If you were convicted of this, you could have a consecutive sentence imposed from that of the underlying conviction. Do you understand the nature of this charge and the maximum penalty?
I do, Your Honor.
All right, then count 3 alleges child sexually abusive activity, distributing or promoting. It alleges and says that you did distribute, promote, or finance the distribution or promotion of child sexually abusive activity or child sexually abusive material. Contrary to Michigan compiled law 750.145C, paren 3, paren A. The SORA notice or the sexual offense registration notice, this is a tier 2 offense under the Sex Offender Registration Act, SORA. It is a tier 3 offense if the defendant has a prior conviction for a tier 2 offense. The felony punishable by up to 7 years and or up to a $50,000 fine plus court costs. Do you understand the nature of this charge and the maximum penalty, Mr. Murray?
I do, Your Honor.
Count 4 alleges using a computer to commit a crime that has a maximum imprisonment of 4 years or more, but less than 10. It reads, you did use a computer program, computer system, or computer network to commit, attempt to commit, conspire to commit, or solicit another to commit child sexually abusive activity, distributing or promoting, MCL 750.145C3. That is a felony punishable by up to 7 years in prison and or up to a $5,000 fine. You could be ordered to reimburse the government for expenses incurred in relation to the violation in a manner indicated by law. A consecutive sentence may be imposed for the underlying conviction. Do you understand the nature of that charge then and the maximum penalty, Mr. Murray?
I do, Your Honor.
All right, Mr. Murray, lastly, the court shall order law enforcement to collect a DNA identification profiling sample before sentencing or disposition if it wasn't taken upon your arrest. The probable cause portion indicates and reads, defendant sent multiple Snapchats of child sexually abusive material through his cellular phone. He also sent threats via the cellular phone that he was going to kill his mother and to be a school shooter. The warrant was authorized and signed 4/11/2023, prosecuting official Christian Cass, complaining witness BJ Can't read that. Oh, BJ Roulette? Maybe. In regard to the matter then concerning the complaint, do you understand the complaint, all of the charges and the maximum penalties, Mr. Murray?
I do, Your Honor.
All right then, Mr. Murray, concerning your case, Mr. Jaspin said that you qualify. He's going to be your lawyer. We're going to set the following court dates for you. We'll set a probable cause conference on April 25th of 2023 at 10 o'clock in the morning. That's going to be with the Magistrate Council. We'll set the preliminary examination for May 2nd at 1:30 in the afternoon. In respect to bond, we need to address bond. Do you wish to be heard, Mr. Jaspin?
Yes, Your Honor. Mr. Murray does have ties to the area. His mother lives here. He didn't grow up here, but he's been here for an extended period. His mother lives here. He advises me that he has absolutely no record, and consequently, no failures to appear. He did sign a waiver of extradition. While these are obviously serious charges, I believe bond should be set in a reasonable amount that would give Mr. Murray the possibility of bonding out.
Ms. Cass?
Your Honor, under MCR 6.106, specifically subsection E, the seriousness of the offense, I think needs to be focused on here. And we do believe that any bond set should be higher. We would also ask for no contact with Mr. Fatia and that Mr. Murray not enter the premise of any school property.
Well, Mr. Padilla is the principal, is superintendent?
No, he does not live in the area.
All right. How does Mr. Padilla fit into this?
The allegation is he was on the receiving end of the Snapchats.
Okay. All right, Mr. Murray. It looks like you're 22 years old. Is that correct?
That is not correct, Your Honor. I am 24 years old.
24, and you're going to have a birthday coming up here in another month or something?
That is correct.
All right. Have you ever been arrested before?
Never in my life.
And how long have you been living in this area?
Over a year now, Your Honor.
And where did you live before here?
I lived in Milwaukee.
And how long had you lived in Milwaukee?
More than 3 years consecutively.
Your Honor, I would
Where
add
did you
that,
go?
I was just going to add that Mr. Murray is employed at the Chippewa Club. So presumably if he got out, he would still be working.
How long have you been employed there, Mr. Murray?
The entire year that I've lived back in this area, Your Honor.
And what do you do there?
I'm actually the lead server, so I have an assistant manager title.
And why did you come to this area?
To be closer to my mother.
Do you have any siblings here?
I am an only child and I have a single mother.
Were you living with your mother up until today?
I was not, Your Honor.
All right, you have your own apartment?
I do.
Have you ever been treated for substance abuse?
I have, Your Honor.
Are you presently in treatment for substance abuse?
I am, Your Honor.
Have you ever failed to appear in court before?
Never before, Your Honor.
All right, then, concerning the matter, Mr. Murray, how this works for purposes of setting bond is different than how it works in the system. Generally, you are presumed innocent unless and until proven guilty by law, beyond a reasonable doubt. When a judge sets bond, the court is able to presume that the charges are true for purposes of setting bond. And obviously, the charges are very disturbing on many levels here. We have child sexually abusive activity followed by terrorism and using the internet to disrupt services and public safety. This is not an appropriate type of case for a PR bond at any level. PR meaning a signature or personal recognizance bond. Given the factors at play, the court ruled that the court is required to consider in setting bond here. And
Your Honor?
basically,
Your Honor, this
Yes.
is, sorry for interrupting you. This is Sergeant Allen. And I just got called by Arraignment Police Department asking if you could pause what you're doing right now before you set bond and call them. Sorry for
I'm not
interrupting.
able
I
to
don't know.
call them. I'll pause it and I'll have the prosecutor call them. How's that sound? And
Okay,
if
thank
it's
you, Your Honor.
something, then you can contact Mr. Jaspin. We'll just put it on pause. We'll be back with you shortly, Mr. Murray. Thank you.
Okay,
Thank you.
thank you, Your Honor.
Who do we need to do? Could you do Mr. Gribble, please, if you would?
Yeah.
Thank you.
You want to, should I disconnect then, or what are we doing?
Yeah, Miss Cass, are you gonna call? Miss Cass, you'll call Mr. Jaspin then?
Yes.
All right, wait for a
Okay.
call. Again, please
Okay.
be seated. Right, we are back on the record in regard to the matter of the people of the state of Michigan versus Adam Fowler Murray, 237391 FY. Once again, Mr. Murray appears from the Dickinson County Jail. Counsel at first appearance again is Daniel Jaspin, who is present via video Zoom. Chief Assistant Prosecutor Kristen Cass is present here in the courtroom. Along with Ms. Cass, we have Chief Mattson from the Iron Mountain Police Department. Is it Edward or Edwin? Edwin. All right, in regard to the matter, we stopped just as I was about to set bail. I'm going to open up the opportunity for counsel to address any issues that have come up in the meantime. Did you want to address bail?
I do, Your
All right, go ahead, Ms. Cass, and I'll give you a chance, Mr. Jaspin.
Thank you, Your Honor.
Honor. Your Honor, that phone call from Iron Mountain Police Department is because they have received additional information this afternoon regarding Mr. Murray and additional threats that he has made to another local school. And we do anticipate further charges at this point. I have been able to view that evidence in the absence or in the break we have taken in the courtroom.
You have or have
I
not?
have. And because of that, Your Honor, we would ask for $1 million cash only bond at this point, as the investigation is clearly unrolling at this time. We would also ask for no contact with Miss Amy Fowler. And when I ask for not to be on a school premise, I would ask that the court specifically order it for public and private schools.
Ms. Cass, I don't believe I'm allowed to set a cash only bond. I think it has to be cash surety.
I don't think you're, that's the option too.
All right, well, I understand you want a high bond at any rate, given all of the circumstances.
Thank you, Your Honor.
All right, Mr. Jasper, do you wish to be heard?
Yes, Your Honor. It appears that Ms. Cass is referring to events that, for which there are no charges, and that Mr. Murray has had no notice of what she's talking about. So I don't think it should be considered for purposes of setting bond for what we have in front of us right now.
May I respond?
You may.
You're aware of what he is charged with is very similar to the video I have been able to see in this brief recess. So I do think it goes to the fact, the charge that he does currently have.
And again, she was referring to matters of which either Mr. Murray or myself has had any notice of.
Well, soon you anticipate filing charges on the other stuff? Any idea? Or do you anticipate, or do you know?
It's very much ongoing this day, Your Honor.
All right. All right. Well, concerning the matter where I left off was stating, Mr. Murray, I had told you that the court is allowed to presume that the charges are true contained in the complaint for purposes of setting bond. And I was telling you my great concern over the nature of the charges, not only the allegations of sexual inappropriateness, but more so, I would say, or I don't even know which is worse, the using of the internet to threaten the public safety. And the terrorism charge is very, very serious here. You're facing a potential on the ones just in front of us of 40 years in prison. And I understand you have no prior criminal history, but for purposes of setting bond, you've come out of the gate with a real whopper here, Mr. Murray. In regard to the matter, you've got no failures to appear. That bodes in your favor. But again, I am looking at, I have to protect the community. I have to protect the alleged victims. I have to presume that these atrocious acts are true as I'm sitting here trying to figure out what to set your bond at. You tell me you're working, you've been working for over a year, that bodes in your favor. But what I'm sitting back and listening to, and I think I heard on the news this week that there's been, and we're in April, over 60 school shootings in this country already this year. We've got a serious problem, and I don't know what's going on. You cannot comment on this. This is just me telling you where I'm coming from in setting your bond here today. You tell me you have substance abuse history and treatment. That's an issue the court can look at. I don't know, and I'm going to presume for purposes of setting your bond that all of that played into the decisions you've made here. And that does not bode well in your favor. I'm sorry. Give me a second here. So in regard to the bond, on the charges set forth here, what's the bond rule? 6 point?
106, Your Honor.
Sorry. All right, in looking at 106.106 subparent F, which is the reasons the court is to consider in setting bond. In addition to the nature of the charges, obviously, is your prior criminal record, including juvenile offenses, your record of appearance or non-appearance, or flight to avoid prosecution. Like I stated, those are voting in your favor based on what I've heard up to this point in time. Your history of substance abuse or addiction does not vote in your favor. Your mental condition, including character and reputation for dangerousness. I don't know much about you other than the nature of these charges, the fact that you were in Milwaukee for 3 years and up here for approximately a year. You said you followed your mother up here. You're an only child. Your mother is a single parent. Although what I'm balancing that against, Mr. Murray, is the fact that she's one of the victims here and one of allegedly somebody that you threatened to kill. So that does not bode well in your favor. So I'm going to presume you have a mental health condition and there's something going on to cause this type of dangerous behavior. The seriousness of the offenses, the presence or absence of threats, those are all against you. Those are all present. I don't have any inclination now on the probability of conviction or likely sentence. It's too early. Obviously, this court has not been apprised at this point of any of the particulars other than that which has come forth in the complaint and that which has been stated on the record by the attorneys today. Your employment status, history, and financial history, as far as I can see at this point in time, you tell me you've been employed as the lead server at the Chippewa Club since the entire time you were here, which is a little over a year. In regard to your financial ability to post money bail, Mr. Jaspin states that it would be a hardship for you to gather up funds in order to hire your counsel. So that leads this court to believe that there is some degree of inability to post a significant bond. However, he did say that there were some assets, obviously, in that it would pose a hardship to liquefy those assets for purposes of posting bond. Any other facts bearing on the risk of non-appearance or danger to the public? As I stated, any other facts bearing on the danger to the public? I think I am free to consider Ms. Cass's statements here this afternoon as far as whether or not there are other potential considerations of danger to the public. They have not been filed at this time. They have not been proven at this time, but it is another factor that I am taking consideration of in setting bail. In regard to the matter then, for the reasons stated, the following are my conditions of bail, and then I'm going to talk about the amount. All right. You can finish filling this in as you call them. You are to sign a waiver of extradition. That's your first condition of release, Mr. Murray. What that means is normally, if you don't come back to, let me preface it by saying, so long as you come back to court, if you post bond, this will never be an issue. If you don't come back to court, normally before you return to the state of Michigan, you have the right to what's called an extradition hearing. The purpose of an extradition hearing allows you to challenge the legality of your arrest and return to Michigan to fight these charges. You have the right to do that by demanding issuance and service of a Michigan governor's warrant for your arrest. You have the right to have an attorney at an extradition hearing, and if you're without funds, one is assigned for you. When you sign a waiver of extradition, if you don't come back voluntarily, when eventually you are apprehended by the law enforcement authorities, you would be returned directly to the state of Michigan without an extradition hearing. Do you understand what that means then?
I do, Your Honor.
All right, that's your first condition of release. You are not to purchase, possess, or consume alcohol or non-prescribed controlled substances. You must submit to random PBTs and drug screens. You're not to enter into businesses that sell alcohol for use inside, such as a bar. I will exempt the Chippewa Club only for purposes of employment and only limited to your hours of employment. You're not to be there beforehand. You're not to linger afterward. Recreational marijuana use and possession are prohibited until further order of the court. You are not to enter the property of either Raul, and that's R-A-U-L, Raul Padilla, P-A-D-I-L-L-A, nor Amy Fowler. And that is their residence, nor their workplace if they're employed. You're not to engage generally in any assaultive, threatening, harassing, or intimidating behavior towards any person. Effective immediately, regardless of whether you're incarcerated or out on bond. You're not to have any contact, either directly or indirectly, with either Amy Fowler or Raul Padilla. That's through any means, personally, in writing, use of a third party, telephone, text message, instant message, email, social media websites, webcam, or internet use. If you relocate because of this no contact order, you must provide the court with an updated address and phone number within 24 hours of any change. If you relocate for any other reason, you must provide the court with an updated address and phone number within 7 days of any change. You are not to purchase or possess firearms or any other dangerous weapons. You are not to be on any school property, either public schools or private schools. You are not to have any contact, either directly or indirectly, with any minors or anyone under the age of 18. You are not to be on any computers, not to have any internet use. You are not to possess any weapons or firearms. You are not to use your cell phone for any internet type of searches, computer searches. What is your position in respect to a cell phone in general? It's hard to live without a phone these days. I don't know what to say. Was a phone used? Was it a phone or a computer we're talking about here?
A phone, Your Honor, that led to counts 2 and 4.
What's your position then, Ms. Cass?
Your Honor, there are phones that don't have internet. I think at this point that would be appropriate. We can always address these conditions later if there's an issue.
All right, Mr. Jasper, do you want to be heard before I make that condition of bond?
I couldn't hear exactly what Ms. Cass said. I guess if it's, I think you should be allowed to use a phone.
He can use a phone. He cannot use a phone with internet capabilities.
Okay.
Is there any other conditions that you're seeking on behalf of the people?
No, Your Honor, thank you.
Mr. Jasper, anything else you want to address on the conditions of bond?
No, thank you, Your Honor.
As far as the amount of bond at this point in time, I'm going to set it at $1 million cash surety. Do we have court dates? We did. Did I set the court dates already? Yes, I did.
Yes.
All right, then. In regard to any issues that come up beforehand, you can always notice it for a bond hearing. But based on what I'm hearing today, I think that's an appropriate bond to start with. I have some grave concerns. In regard to the record, then, do you understand those conditions of your bond that I've gone over here, Mr. Murray?
I do, Your Honor. I do have a couple of questions, if that's all right.
You do? Let me tell you something first, and then we'll go over your questions.
Okay.
For the record, I'm going to find that the conditions of release are reasonable, given the nature of the charges. I think the protective conditions as outlined by the court are necessary. I have informed Mr. Murray on the record the conditions of his release. In regard to the matter, then we're going to go over any conditions of that you have questions about. Mr. Murray, if you violate a condition of your release, you're going to be subject to arrest without a warrant. You could have your bail forfeit or revoked and new conditions of release imposed. In addition to other penalties prescribed by law, you could find yourself in contempt of court for violating bond conditions. Do you understand that?
I do, Your Honor.
All right, so I'm going to ask you what your questions are. I'm going to preface it by saying courts are not allowed to give legal advice. It may be something I'm referring you back to your attorney for, but go ahead.
My first question, Your Honor, was just referring back to our meeting earlier. I got the dates of my next two hearings with you, but I did not get both the times. I have down April 25th and May 2nd. If you could please
Yes.
go over the times of those again and exactly what those are and what those refer to with me.
Probable cause conference, April 25th, 10 a.m. That'll be with the magistrate, not myself. The preliminary examination is May 2nd at 1:30 in the afternoon. That will be with me. In regard to the nature of the types of hearings, I'm going to refer you back to your attorney to discuss what happens at a probable cause conference and what happens at a preliminary examination. You'll also get these dates and times in writing.
Okay, thank you, Your Honor.
Is that your only questions then?
I just wanted to know when my, when will I next be speaking or have the chance to speak with Mr. Jaspin? And I had originally, before this updated meeting, is it my understanding that he will be provided to me free with the court, or I do still need to charge? Because in the case of paying for an attorney, my mom had been willing to do so. So with a no contact with my mother, not only will I not make bail, my mother is Amy Fowler, who the no contact with. I will not only not be able to make bail, but also not pay for the attorney.
Well, in regard to the matter, again, you can go over those with Mr. Jaspin. He's been assigned as your counsel. At the very end of the case, the courts deal with the cost of attorneys. So it's not something you need to worry about at this point in time. He's being assigned. He said you qualify for assigned counsel. So that is not something you need to worry about right now. As far as hiring counsel or any of those other issues with the no contact, you'll have to speak with your attorney about those.
Okay, Your Honor. My last question for you is, I'm not sure if this is appropriate or not, but is there any timeline at all that my mother will be able to have contact with me again? How will she know the updates of this, and how will she know to not contact me, and will understand why I'm not contacting her?
Well, these are the types of issues typically you discuss with your lawyer, but your mother can contact the victim witness coordinator through the prosecutor's office. I'm sure they've already been in touch with her. They'll keep her apprised of the status of the case and those other types of nuances like no contact orders. In regard to the issue of when your lawyer is going to see you, they are required to see you within 3 business days of today's date. If you get out of jail or post bond, you make sure you contact Mr. Jaspin. We're going to give you his business card along with all of your other paperwork. Does that answer your question?
It does, Your Honor. Thank you very much.
All right, thank you. We'll see you soon. Mr. Jaspin, anything else today?
No, thank you, Your Honor.
Ms. Cass?
No, Your Honor, thank you.
All right, thank you. We'll be off the record.
Well, there you have it. Our brain surgeon of the day, Adam Murray. And don't forget to hit that like and subscribe. I'm Phil, and you've been served.